I didn't have enough. Thank you so much.
Thanks for all your help, man. That was a great pivot.
You too. Okay, if you guys won't be able to see anything on the screen, you're free to join the Zoom if you need like a closer view. We might have an extra printed out of some of the articles to pass around if we really want to as well.
We'll do our best to try to explicate, but we're gonna maybe get deep into words today, sorry.
Might be a wordsmithing day.
Okay.
Okay, I think we're good on our end then.
Okay, yeah, we're ready to start whenever you are. Just
Okay.
keep an eye out for Dr. Travis if you don't mind.
Yeah, I will. Right, do you guys have any articles to?
We actually have a couple, but I'm gonna need to caucus with my group first, so if you wanna go ahead, and then if we wanna take a quick break, I think I'll be able to bring at least one, if not two afterwards, but I need to circle up with them because a question came up last minute.
Okay, I'm gonna send this email out to you now.
Okay.
We have a bunch to go through, so.
Okay, great.
We should be fine to fill our time at the very least.
Okay. Before we start, can I ask really quickly about 8, 9, 19, and 20?
Yeah. I think. That's-
Yes,
Yeah, we're gonna talk about that in person. She has the DocuSign stuff. I
Yeah,
didn't get it until she's done signing it, so.
but we need to go over to make sure the words are correct.
Perfect,
And
okay,
we
great.
simply haven't gotten to
I
that.
honestly, I just wanted to make sure that, like, if there were, I didn't know if we were still like on the way to being done, or if we
Yeah.
needed to substantively continue to work
No,
on it.
they're in my inbox, but we just like.
We're gonna have
you
in
know,
person.
Please, no,
Yeah.
Double
that's-
check
no, I-
everything
yeah.
and we
I
just
please
haven't
do,
done it.
please do, because if, I mean, I'd appreciate doing, I just, like I said, I just want to make sure that you didn't see something already that you're like, oh, no, this is wrong, that's all.
No, we haven't
Okay.
seen that yet, and that's exactly what we need to look
Perfect,
for.
no, that's great, I appreciate that, okay, good,
Okay, we're gonna start with Article 4.
okay.
Let me get this set up as best I can here.
Oh, man,
Yeah, I have printed out copies of everything, but
Can you
I normally am
zoom
happy
in
to look at
really
the screen, but
far?
if there's any way you've got a printout that we could look at, that'd be
Yeah.
awesome.
I will do that.
Can we just scoot it closer?
A closer would make it smaller.
Oh, true.
Yeah. Let me,
I hadn't thought that one.
When you forward it, would you be able to just send it directly to Shane and Judy and Robert, or do you need me to forward it?
I believe I got them all when I sent this email.
Okay,
out.
great.
Yeah, Shane, Robert, Judy.
Perfect,
Um,
thank you.
And Tom all got it.
Great.
Okay, that's not too bad. And then let me get the printouts.
Is there a way I can make it turn like?
Do you mind?
Maybe, yeah.
Mhm. And I mean,
Is that?
That's way better. Yeah.
I got what you were saying. I appreciate it.
It's totally washed out,
Okay.
I was having a hard time.
I'm presenting this. Yep.
Okay.
I can also open it on my computer so that you don't need to give me a copy. if
Well,
you
we'll just
want.
print out for you guys. And
Thanks.
then I guess that's gonna be maybe more than you guys have. I don't know if that's 2 or 3, but.
It's really just the one. Yeah. Probably on the back. And it looks red on the printout.
Yeah.
I don't know if you want to have more to give to your folks here, that we only need 2.
Green on this.
Yeah. This one.
Judy, Shane, and Robert, can you just confirm that you guys have it?
I haven't received the email yet.
And we could wait until
Yeah.
they get it.
It's
Mine
one
just
copy and I
came,
just,
so- Okay,
I just opened it to the correct. version. It's just a 6-page document.
I have mine.
Okay, perfect, thank you.
and do you wanna?
Yeah, sure. So for anyone in the room / on Zoom, we are talking about Article 4, which is appointments, reappointments, and terminations. We, I believe, are in agreement on absolutely everything up until the final provision, which is 4.8,
Okay,
and talks about summer appointments for
Okay.
GAs. The language that we had talked about, we've gone back and forth a few times.
Yeah.
You had brought back language that we thought was constricting. You brought back a second reiteration to try to clarify,
yeah,
which we still found really confusing.
okay,
And we were attempting to basically enumerate all of the different ways that people could get summer appointments
okay.
within what you brought.
Yeah, because you gave a number of really good examples last time that we may not have
And so
accounted for.
what I realized is I really tried to wordsmith within what you gave us
Okay,
is I think it's easier understood, written in a different way. And so what I've tried to do is I incorporated our most important things in the top two sections. And then I incorporated your most important thing in the bottom, and I can just read it to you. So it now says 4.8 summer appointments. The purpose of summer appointments is to allow graduate assistants and graduate students to be employed by the university when they would not otherwise have been. Summer appointments are therefore intended for GAs with a regular appointment period that is shorter than 12 months, GAs with irregular appointments that are shorter than 12 months, and graduate students who have not had a GA position in the past. And so section A now says, in accordance with Article 4.3, which I can read to you, it's just the part that says, like, we acknowledge together that a 12-month appointment provides job security for graduate assistants. So in accordance with that acknowledgement from all of us, we together, again, acknowledge that providing summer appointments to GAs and graduate students is not intended to allow hiring units to shift existing 12-month GAs to shorter appointment periods, nor is it intended to allow hiring units to shift their future hiring practices away from 12-month appointment periods in order to not offer summer support. I think we should be in agreement with that. We've talked about this in the past, and you have said very clearly, Patrick, that that's not the intention of this provision.
Right.
And so section B now, I'm hoping will address what Judy specifically has been trying to explain to us, which is this very narrow situation. And I can just read it. It says tuition waiver exception. In only one situation may a graduate student not be provided a tuition waiver for a summer appointment in accordance with 11.2. And this is for continuing 9-month employees who receive a summer appointment that's outside of their unit and is substantively different from their regular 9-month appointment. And they may or may not be awarded a tuition waiver for their summer appointment at the discretion of the hiring unit. And that they must be notified of this at the time of the offer. The previous language basically narrowed in summer appointments to only being for continuing 9-month GAs who had a previous appointment and a future appointment that were 9 months. It was specifically like intervening 9-month summer terms was how it was written.
Gotcha.
And so we want to make sure that all GAs and graduate students, right, who might not be currently GAs, have the option to be appointed for the summer. And we hope that this section B now satisfies this specific situation that Judy has told us about with like Whitney Lab people. Without narrowing in who can get a summer appointment.
Yeah, and it's written in such a way that that is the one exception, so we
Right.
shouldn't have to worry about any of the expansions of this effect.
Sure. So I have one question, and maybe it was an intentional change or not. So I think that there, and Judy, you may have questions too, so I'll ask one, but then by all means, if you have some, please chime in. So the, in our previous one, we had used and or, and you guys just have and. I don't have a line number here, but it's in 4.8B1 in the second line. So here would be my question. Is the intention, if we had someone who was, is the intention that it only is somebody who is switching both their responsibilities and also their unit?
Yeah.
Yeah,
Okay, so that's the intention. So if I was
Can I give you my
Yeah,
example?
go ahead.
Because it's literally me right now.
go for it.
So I am currently a research assistant in the Department of Sociology.
Mhm.
In the fall, I should be a research assistant in the Department of Sociology. I have a grant thing, which is why I'm saying maybe.
Gotcha.
And in the summer, I will be teaching in the Department of Sociology.
Okay,
So I'm still within the unit. I am doing something substantively different, and that if this were and or, it means my department could not provide me a tuition waiver.
right,
And
understood.
so we do not want that to be the case. We want it to be outside the department and something substantively different.
So what about for people that are going outside their unit, I guess? So here's a different example, but it's where they maintain the same responsibility but switch departments. So like, let's say you were teaching in sociology,
Mhm.
but you have the opportunity over the summer to teach in the history department.
Mhm.
You would, based on the proposal, I just want to make, I'm not
Yeah.
arguing, I just want to make sure I understand
We
it.
still want that
You would say,
department to offer a
no,
tuition
you
waiver.
can't do that. You would have to pay for a tuition waiver. Okay,
Because we want this to be as few cases as possible.
sure, no, I get that,
If, in your situation, just wanna play this out. If I'm thinking I'm a department chair in summer, and this happened before when I was an undergrad department chair, and I'm realized, I need somebody to teach a course in summer, so I'm gonna go to the grad associate dean and say, do you have anyone available?
Mhm.
And they may say, I've got someone who was a research assistant last spring, they're gonna be a research assistant in fall. You could hire them, but you've gotta pay the tuition waiver. That's what you're asking for. You wouldn't want an option for me to just be able to hire.
Right, the default is tuition waivers paid.
Okay, cause if
We're-
I'm, all right, cause if I'm,
We're
if I'm,
offering
if
an
I'm.
exception,
Right.
and we want that to be as few people as possible.
Okay, but okay,
Yeah.
if I'm the department chair, I'll be like, okay, fine, I'll find an adjunct, just by the budget. So that's the competition. Okay.
Okay, that's fine. I think we understand it. I mean, I think, yeah, I appreciate the clarity. I mean, you've made it clear sort of what you want. Judy, did you have any questions?
No, I do like the clarity, Hannah. Thanks for taking your time with this. I do, Patrick, your point is, we did have examples of outside their home department getting hired to teach and the waiver, not being offered like they didn't, nor did the student want it. And so I think that might be challenging. And so would there be, like, I don't want to write it in for all, but like in those circumstances, where the student doesn't want it and it is outside their department, could that like be petitionable? Do you know what I'm saying, Patrick? Like, because we had those scenarios where, like your example, they're sociology, but they went to history. They
Right.
hired, the history department hired them and they didn't have the waiver.
Yeah, what I think I'm hearing is you guys are like, just hire him as an adjunct. We don't want it to be inside the bargaining unit. That's what I think we're hearing, is you would say, no, we don't want that to be considered GA work unless it's attached to the waiver.
Well, to be a GA, you have to pay credits. You have to be enrolled,
Right, but to be an
Right.
adjunct, you don't.
correct?
Yeah, so if that's the case. I'm answering Judy's question in the positive rather than the negative.
yeah.
What I'm hearing you all say is, look, in that case, we would prefer if you just hired them as an adjunct if you want the same person.
Yeah, that's fine. Pay them, but don't require them to pay 3 credit hours of tuition and fees.
Yeah, that makes sense. Hey, can you do that? I always thought you couldn't.
Yeah, I didn't know that you could.
If they're not
even
a
hire them
GA.
as an adjunct.
If they're not
If they're not
GA,
registered in summer, you can hire a grad student.
Yeah, I wasn't,
You're-
that,
That
I
was-
think that we need to talk about, Patrick, a little bit more because adjunct's been reserved for, in the past. Now, I'm not saying it has to be, but I think we need a clear understanding of what an adjunct is, because regarding the principles of employment, we go by the duties of a graduate assistant and what that reflects, and that's how we encourage departments to hire. So I think talking, if we could all just talk maybe about
Yeah.
adjunct with Robert and HR.
sure,
Yeah.
yeah, I
Can I
mean,
also
oh,
ask
go
a
ahead.
question?
Sure.
Like, and maybe you don't know the answer, but so let's say if a GA is then switched to an adjunct for the summer, does that have like any implications for their GA shift after, like in the fall?
Yeah, I think it's a good question. I think what Judy may have been alluding to, and I'll just be transparent, I think what it's probably going to do is make it to probably where, because of a concern about that, we just hire a typical adjunct and not a GA trying to be an
And
adjunct.
that was a scenario I was
Yeah.
playing out, and. Right, because it's cheaper, and then in fact, that's even worse, because from a grad student's point of view, because you're not only not getting the waiver, but if you
Yeah.
were hired as an adjunct, you're actually getting less than you would as an assistant and no waiver. But the only reason I introduced that scenario is when I said an adjunct, I meant like somebody who's not a grad student.
Right,
Yeah,
yeah.
that's what I was.
Hannah, Hannah, can I ask, is your fear that you see departments withholding that benefit of tuition to the student who the student does want to have the tuition? Or who the student does want to be registered?
The student has to be registered, right? So if you get a GA position, let's just use the summer, because that's what we're talking about, right? So if you're in summer B, you have to be enrolled in 3 credit hours to be a graduate assistant. And what we don't want to have happen is to force graduate students to pay 3 credit hours to get paid right? Cause that's ultimately what it is.
Right.
It's like being an intern and paying tuition to volunteer.
Mhm.
Like,
Right, there's some, it seems kind of circular.
Right,
in
and
some
even from
respects.
the department's point of view, like, wow, I'm gonna have to pay them to pay tuition that's supposed to, like, I'd rather just
Well-
not have that tuition.
Yeah, and as we talked about before, it's especially problematic with the example you're using because a lot of the faculty in those departments where it'd be relevant don't have 12-month faculty, and what winds up happening is the
Mhm.
oversight of those GAs rolls up to a department chair or grad coordinator who is 12 months, which isn't your normal PI. I mean, we've had that conversation at the front end of this conversation, so there's also some practical problems with
Yeah.
it too.
I think if we were talking about a situation in which a summer appointment could not have to pay tuition, that would be a completely different conversation.
Right.
What we're saying is that the university doesn't have to pay for our tuition, which we are still required to pay.
Gotcha. No, I think we get it.
Yeah.
I think we get it. All right, you wanna keep going?
Yeah, we can move to the next article here. I mean.
Oh, is it, did we get through the whole thing?
Yeah,
That's it.
they-
That's all we
they-
need to talk about in four, is just this
Just
summer
for
appointment
eight,
thing.
yeah,
And everything in front of that is.
Everything
agreed
else is
to.
done.
yeah. We're very close.
That's, yeah, I think because here's the thing, on this one, I think we agree in principle. I just think we all just want to make sure that we don't inadvertently create a scenario
A
where
bunch of loopholes.
someone winds up either frankly using gamesmanship or some narrow interpretation to get around what we're trying to actually make happen.
Right.
Yeah, that's
So-
why I wrote
No,
that.
I get it. I
And if you
appreciate
guys
it.
need to adjust it a little bit, I'm
Yeah.
not a lawyer, so.
No, I think, but, yeah, I think if you would give us some time to kind of go through it together and run through some of these scenarios. And look at it in the context of some of the examples that had come to us initially when we started this conversation a year and a half ago. Just to make sure that, this will work to, again, accomplish what we want and prevent what we don't.
Yeah, and
So,
our intention, like my intention in writing V the way I did was to hopefully address the very narrow situation
right,
Judy's been explaining to
Sure.
us, and if I didn't do that properly,
got it.
it's just a miscommunication.
Okay, great. Appreciate that.
Okay, let's move to our next article here. Which is gonna be Article 7.
Okay.
My computer's showing to exist, but it's fine. Okay, I believe on Zoom I shared my screen, so you should be able to see 7 without me having to mess with it too much.
Yeah.
Perfect. And then Ava, if you wanna take the lead on this one too.
Yeah, so this, I believe, we're only looking at 7.3.
Okay,
It's where, we've made changes. I think everything else has been agreed on, right? So we have conceded to some of the language that you provided saying that, the parties acknowledge that the time to complete a science task varies based on a number of factors, including an employee's individual expertise, abilities, and experience, as well as the timing and completion of a science task, which may be determined by the employee in some cases. And then we've added, also, a statement that we hope also reflects something that you acknowledge, that is that the time spent on the task is and should be regarded as contracted work, and is subject to the limits of, set in 7.1, regardless, exceeding contracted hours. Right, so even if people have different skill sets, different, individual expertise, abilities, so on and so forth, that, sorry.
Sorry, we had multiple people do this and I didn't remove the edits from multiple people, so. I'm cleaning up this one to say what the
I gotcha.
language should be, because all of this sentence is new, so this should be what the
Sorry, yeah.
sentence
Okay.
reads as.
Okay, the parties acknowledge that the time spent, I'm sorry, go ahead.
Yeah, so that it is, so that time, even if there's two people that have different skills, the time that they are spending working is time that they are that is spent working, and therefore, if one of them is overworking, or working over the contracted hours
Right,
on a regular basis, right, going over their average, as indicated in 7.1, that is, excess work, that is overwork, right? And that they should, be able to take steps to resolve, this overwork, including but not limited to filing a grievance. And then we've also left, point A, that is your, 7.3A is yours.
Okay.
And then, we rejected 7.3B. We felt that it was creating a space where, GAs can be overworked, per contract, and we didn't like that. And that's pretty much it.
Yeah, I believe all of our changes are within 7.3 there.
Okay. You have any questions on this one? I've got our version right here if you want to look at it side by side.
No, I'm good.
Again, we're hoping for a compromise medium ground, right? Where we get some of the language we're interested in and the clarity that we're interested in.
Sure.
While leaving in some of the concerns that you all have.
Yeah, no, I appreciate that. I mean, I think, just kind of like I mean, we spent a lot of time on this article. But I think our position remains. Look, we want, when we have faculty members or supervisors that are inappropriately overworking their GAs, we want to have language that supports your ability to contest it and our ability to support a grievance where there's a legitimate violation. I mean, I don't think we disagree on how, we have disagreed on how to exactly to word it, but I think I think on that we agree. So I appreciate the work that you guys have done on this. This is one of those that's pretty technical because it is very much one of those things that we want to, run through various scenarios, and look at like hypothetical grievance cases to see, just to make sure, but, yeah, I think I can say pretty confidently, we're as close as we have possibly been on both 4 and 7, which is very encouraging. Shane or Judy, do you have any questions on this one?
No,
Okay, do we want
Great.
to move on then?
Yeah, let's go ahead.
Okay, so we're gonna kind of do two at once, but it'll be a little bit weird. So on the screen, I'm gonna put up, another proposal for Article 10 from us.
Okay.
But at the same time, I'm gonna hand you, for Article 10 and Article 16. I'm not gonna put 16 on the screen, because, as it was before with us, this is a, resubmission of our previous proposal.
Okay.
We have a couple spares here, and we think that it is a fair proposal, obviously, for what we've done before. Here's a copy of 16.
Okay, thank you.
16 should not be changed from what we were last time. 10, we're gonna see, some significant differences, so,
So this, I just want to make sure I get this. This is, Article 16 should be a verbatim reassertion.
yes, yes, it should be,
I'm just gonna make that note in here real quick.
yeah. But Article 10 is not. I'm giving to you at the same time because for us, a lot of what we're coming down to in 10 connects with 16.
Okay,
Just in terms of where we want to see the contract end up as, obviously, we have very opposing viewpoints in both of them. We have
Right.
not made much agreement in either of these cases, and for 16, I think we both reasserted our previous proposal a couple times at this point.
it's true.
And for 16, we are reasserting, very close to current contract language, but we are stating that things don't happen in a vacuum on this contract, and we're
Mhm.
willing, once again, to make movement on Article 10. To try to, say, let's find some place where we can agree to all articles here and find that place where we can go to ratification, sooner rather than later, without too much delay. So, for Article 10, most of it is going to be the exact same.
Yeah.
It really is, pretty much none of the numbers past, nothing past 10.1 changes. 10.2, 10.3, 10.4, all of those are the exact same as we gave you last time.
Okay.
The changes happened in 10.1 and what was 10.2. So 10.2, if you recall, was an automatic raise to the minimum stipend to match the I think it was the F1 visa on this latest one.
Mhm.
And while we still believe that that is something that is a fair thing to do, we have dropped that. And we've also dropped our ask for the minimum stipend from 26,000 for a 9-month employee to $21,600. Now this is still not where you guys are at. It is $1,000 above where you guys' latest proposal was.
Mhm.
But we think this is a fair drop off. We think this is something that, you know, obviously we're not happy to do and not something that we wanted to do for GAs. We think 26,000 is a fair number to pay a 9-month GA at the minimum, but we're willing to make that movement and say, let's find something that we can ratify. And so we talked about it a lot. We talked about what that number would be, and that's pretty much as low as we're willing to go with these two things in conjunction. That's not a last best final, but that is, you know, in terms of the minimum stipend, that's as low as we were comfortable going in this moment. And so, yeah, do you guys have anything to add about that?
I just want to stress that the last proposal that UF gave on Article 10 stipends was what, September?
September 30th.
30th, 2024.
Yeah.
It's been a long way, and you know, I wanna say it has been a lot of GAU work trying to get this ratified, and I feel like it is now, and it has been for a while, UF responsibility and duty to meet our effort.
Mhm.
So,
Yeah, but we've said again and again that we're not gonna bargain against ourselves, and that's what we keep ending up doing. But when it comes to the minimum stipend, we're not gonna do that from this point forward until we get something where we can say, let's have a conversation about this beyond the automatic reassertion. So this is our attempt at not saying, you know, playing hardball, not doing that. It's saying we want to get to ratification. We know you guys do too. We're willing to make those movements to get there. And so we hope that can be reciprocated.
Questions? Judy, Shane, Tom? I don't have any questions. Okay,
Okay. Move on from 10 and 16 then. And the next ones are also very hopefully it'll be a little quicker here. So we have 4 that we haven't really gone through in a while, and it might be hard for my computer to handle all this, but start with, we have Article 23, which is the totality, or 23, totality of agreement. It's been a while for some of these.
trying to figure out when the last time was we even talked about that.
I think it was like
April of
last,
24?
yeah, it was last March or April, yeah. And a lot of these we've been sitting on because they make connections
Yeah,
with
yeah.
Article 24.
No, we agree, we agreed on that.
And we think we're at the point, we're gonna give you 23, 24, 25, and 28. And we believe where they're at with our language and our proposal on that we're comfortable with these 4
Okay.
as they stand.
All right.
That doesn't to say 24 and 28, we do have changes from what you guys proposed
Okay.
last time.
All right,
But they're not gonna be very significant. So 23 should be the same as we talked about this last year. Nothing should be changed from around a year ago. 24 will have some changes to it.
do you happen to remember, I mean, it's okay if you don't, because we can do a close reading of it. These are some of the more technical ones. Do you
Yes.
happen to remember? It's not changed from the last one you proposed or the last one we proposed? Do you happen to remember?
I believe 23 was the last time you proposed it.
Okay.
I
So
think,
there's a good chance it matches our last one, which I think was April of 24.
yes, I believe it should.
Okay.
And if it doesn't, I can always send a copy of what our last
That's
one
fine.
was as well.
That's, I have them both. I just
Yeah.
want looking at which one we should open.
Yeah, and then 24, we have made some changes. So 24. Here's a couple copies of that.
Thanks.
And did you make modifications on 24? Did I?
I think maybe both of us touched that one. There
Yeah,
were a
this
couple
was-
that you edited and then I edited after you.
I think this one was March of 24.
This one is the one, all I added was or reinstating down here.
yes, I can't remember if we changed anything else.
It does look purple in there.
Yeah, I believe that's the only change then, except for 24.3.
Yeah, 24.3 is stricken.
24.3 is stricken, so what happened is, we added 24.3 as a subclause, it's not current contract language. We've gone back and forth a couple of times, and on the latest, proposal, UF added, an extra sentence, which is the except for any authority that is legally permitted to do so, including the legislator and the courts of the state of Florida. And just going through that and trying to understand what we were trying to get from 24.3, we just think we're happy to go back to current contract
It's
language. Just
super
not have that.
muddled. Yeah, it's super muddled in terms of.
Yeah. I would just say we're happy to just eliminate 24.3, go back to current contract language where nothing is in there about authority. And just keep the 24.1 and 24.2 here.
24.1, 24.2, all right.
Yeah, and the only changes in those should be the or reinstating at the very end of 24.2.
Do you wanna read or do you want me to explain or reinstating yet?
I'm just making a quick note of like, which, like the deviation from CCL. Just give me 1 second, man, if you don't mind.
I think it's just literally the extra sentences. I think the black text was
Yeah, that's
CCL and,
the same.
anything colored as additional.
All right, go ahead.
So in, that's thank you. So this statement is basically saying, I can read it if you want, it's so legalese. If any provision of this agreement is rendered invalid by subsequently enacted legislation that is later wholly or partially upheld through a final adjudication, the university agrees to engage in collective bargaining with GAU regarding the provision with the intent of preserving, and then I added or reinstating the language. And so this is basically 2 steps in, right? Something has happened where we need to change the contract. And now it has been reversed.
What line are you in, Hannah? I'm sorry.
I'm down here at the bottom of 24.2. I've added reinstating in 23. It's very subtly a different shade of red. It's kind of magenta-y.
Yeah.
It's this right here.
It's at the end of that line.
Got it. Okay. Oh, I
Okay.
see. All right.
And so I don't know who wrote it, but this sentence had existed already where it said we would try to preserve existing language in case something was reversed. But there is a very large chance that by the time we get there, that we've already impact bargained and changed something. And so I added or reinstating as you think through the realistic possibility of this situation,
Yeah.
right?
Mhm.
Where if we're thinking about preserving, reinstating would just be if it's been taken out. So a good example could be dues deductions.
Mhm.
We've impact bargained to take that out. If that ends up becoming legal again and it's already been removed, we can't preserve it, it's gone, right? And so
Yeah.
we would have to reinstate it.
Yeah,
Yeah, I think so. I would defer to Shane on this, but I think that we would want to structure it in such a way that the language, even if idle or suppressed, for lack of a better term, remains a part of the agreement as opposed to having to, like, creating a hardwired mechanic that would reach outside the contract and put something back into it, I think is problematic. So
Well-
then, like, rather than saying reinstating, it would inform the way in which we would impact bargain,
I
if
just
that makes
wanna,
sense.
we've had this conversation in the past, and I'm pretty sure we're under the assumption that we could leave something in that is not okay, right? That is not
Not
able to
enforceable.
be implemented.
Yeah.
And I'm pretty sure you all very clearly told us that we were wrong in that understanding
Depending on
and
how
that
it's
we had to
constructed.
remove it.
So depending on how it's constructed, so, I have an example of one that we did before. I don't have my hands on it right now, but I wouldn't mind sharing it. It wasn't a GAU agreement, but, I will bring it or I will email it and we can talk about it next week where I think we are able to legally construct it in such a way that it's not currently binding. It's almost like, for lack of a better term, like dormant,
Mhm.
but specifically says something along the lines of, and keep in mind, I'm not an attorney, so I'm gonna defer to the construction
Mhm.
to Shane, but the following provision is unenforceable until and unless, and then it uses some of these same things. enjoined, struck down, repealed, modified, blah, 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 blah. So you can leave it in there almost as almost
It's
like
a
a piece of
stasis.
legacy language. And it can possibly never come to be unless there's some sort of legal change. That way you don't wind up, again, my concern would be having to go to like, you make the current contract legally binding on the subsequent agreement, and you really shouldn't have anything that's not in the agreement be a binding part of the agreement. Like, it has to be in there in some form or fashion. But I think I have a couple examples, or at least one that I'm thinking of very clearly, and we can sort of share it with you, but I think what you have here is something that we can probably work with, and I think we can probably come back and maybe incorporate that into what we bring you all hopefully next week.
You understand the idea, right?
No, I think I get you. Because it's not, the phrases that are in here are very similar to what we kind of put initially in our MOU on dues deduction.
Mhm.
Like a lot of these phrases, I mean, it's not exactly verbatim,
Right.
but it's very, very similar.
Right,
So, I mean, I think we have a way forward to get this done.
yeah, okay,
Sure.
just, okay, you get it.
Yeah, I got it.
Okay, we've got two more for you here.
Okay.
One, again, no changes, whenever it loads. This is 25, it's just the duration of the contract.
Okay.
We've gone back and forth a couple times, but once again, for like a year, on this. And it's one of the ones where we haven't discussed it because it's one of those ones where you put your reopeners and
Yeah,
things.
yeah.
I don't think we're at a point where we're gonna need those. So, this is, we're just happy with the language as it is and stating that we're pretty comfortable with that.
So, so now you have brought two of the ones that I was actually gonna bring, so now I'm not gonna give you the ones that I was gonna bring, but I will just kind of have a comment on this one.
Mhm.
Is that we have actually had, some significant legal discussion about whether or not we have to consider the bargained period part of the 3 years. And, we believe that we don't actually have to do that. So if the union would be amenable, we believe that we actually get a 3-year period to have the contract be in place from the time of ratification, as opposed to when we started bargaining and the run out of the previous contract. So I don't know if that's something that you all would consider doing, but we would especially considering how long we've been engaged. I mean, I appreciate the fact that I agree that this would be the date if we ran the next one right up to this one, but we have been able to, we believe that we have the ability to look forward from the date of ratification for a 3-year period.
Mhm.
And, I just want to tell you, we're gonna probably bring you a proposal to that effect, and we hope you would consider it.
Okay.
Or I think we will consider anything you bring to us. I
Okay.
think instinctively, that's something that, I think we'd have to know that it's done in good faith and we,
Absolutely.
because by default, it's, not a good situation I would want to normalize.
I get it.
Because that would incentivize slowing down negotiations, because then you slow
100%.
down all future things.
I understand.
We're happy to look at whatever you do,
Gotcha.
but, I'm gonna
Okay,
err on the side of caution on that.
sure. No, that's fine.
Yeah.
I'm not expecting you to agree to it right now. When I come back, I feel it would, for me to sit here knowing that I'm literally sitting on a proposal that looks like that I'm now not gonna bother to hand you because you just handed me one on 25. If I don't say it out loud, I'm gonna feel badly because it's literally sitting here, so.
Right.
Mhm.
But we'll go back and look at ours again in the light of the fact you now have put this in front of us, so,
Okay,
thank you.
and then we
Yeah,
have.
28?
We have 28 for you
Okay,
here.
great.
28.
How are we looking on that one?
We've made some changes to it. I think we're not too far off,
Okay.
but,
This is another super technical one.
yeah.
What's that? It's 28. So we're not gonna, like I said, we're not gonna bring it now because you now have a proposal on the table. so-
Yeah, and this is one where we've gotten close on it, and it's one of those things where it's just the wording on a lot of these things. So sort of the differences here are, we've reworded the start of B. It's the same thing. It just said before, for circumstances not covered by the above. So we just said specifically in 28.1, if the university adopts a new regulation, policy, or resolution, or amendment to an existing regulation, policy, or resolution that has a direct and substantial impact on wages, hours, another term or condition of employment, or any other provision of this contract, the university shall engage in collective bargaining obligations with respect to changes prior to implementing it for members of the bargaining unit. In your last proposal, we had a list of kind of options that GAU could do, and you had struck that out.
Right,
And, we, are okay with getting rid of most of that list, but we do believe the idea of waiting to reopen until we get back to full book bargaining is something we're interested in keeping as an option for some of these regulations. As it stands.
Especially considering the conversation we just had.
No, understood. I'm sorry, I'm not trying to make you sit here and look at me read this, but
It's all
fine.
legally stuff,
It-
like we're,
it's a
It takes a
technical,
couple
Yeah.
it's a technical article.
Yeah, sorry for the readers.
No, it's, the last 4 or 5 articles are always like this.
Mhm.
And you would think that because they're in almost every contract, they'd be relatively standard, but the bottom line is that being off by 2 words sometimes make an enormous amount of difference. So I guess my question in terms of the way it's constructed.
Yeah.
Is. The phrase that starts with the word that. In line 12, this is gonna sound like a ridiculous question, but I think I need to make sure I understand.
Yeah,
Which reads, that has a direct and substantial impact on wages, hours, another term or condition of employment. And then the or.
and then any other
Any
provision
other
of this
provision.
contract in the next line.
Right, so is any other provision of this contract connected to the phrase that starts with that? Or is it another category that is listed in lines 10 and 11?
It's a category in the list.
So I guess what I'm saying is,
Wages, hours, terms and conditions, other provisions.
Yeah, so
right,
it's
okay,
in
so
that
that's
subclause.
what I
Yeah.
wanna make sure.
Yeah.
I don't want, it's not, it doesn't read. If the university adopts a new regulation, policy, or resolution or amendment to an existing regulation, policy, or resolution that has a direct or substantial impact on wages, hours, other decision, or new
Or
line,
creates a new
or
provision.
other provision of this contract. Like it's not, it's
You
connected
guys
to,
can't do that, right?
right,
Yeah,
So,
right. I just
No.
wanna make sure, okay.
Yeah.
Okay, I think I get it. This is one of those where I have to like read it and then kind of set it down and kind of come back to it, and then we're gonna have to. probably
yeah,
have some-
especially with a lot of the different colors and crossing out. and
Yeah,
stuff,
yeah.
it's
I
not easy.
probably what I'll do is, when we bring this one back to you, whether or not we have changes to it, or if we find it acceptable, I'm probably gonna go ahead and just clean it up
That's
so
fine,
that
yeah.
it's a little more readable, because
that's fine.
these ones, when they get super technical. Okay. Shane, do you have any questions, or Judy, do you have any questions on these ones?
No,
Okay. Well, I appreciate all the ones that you guys brought to us today.
Yeah, we tried to,
28. Or is there?
Oh, here you go, sorry.
Thank
There you
you,
go.
okay.
Sitting
yeah,
on
we
both of them.
tried to clean up and go through as many,
Yeah, yeah.
especially ones we've been sitting on a while.
Right, no, I think that's great.
I think the only major one we haven't discussed today is 13.
Yeah, so can we just do a quick accounting then of where we are? Would that be okay?
Yeah,
All right, so I've got, 1, 2, and 3 are TA'd.
yeah,
4 you just gave us today, so that's on our side of the table as per 3/28/25.
Mhm.
5 and 6 are TA'd.
yeah,
7 is are on our side of the table as of 3/28/25. You just brought it. 8 and 9 are both in DocuSign pending a close read by y'all.
Mhm.
Yeah, pending TA there.
Okay, 10 is on our side of the table. Technically, you just brought that to us today, 3/28/25.
Mhm.
11 and 12 have already been TA'd.
Mhm.
13 is on our side of the table, and I'm gonna endeavor to bring that back to you, next week.
Okay.
So, this one's already on our side of the table. 14 and 15 are TA'd.
Mhm.
16 you just brought to us. 17 and 18 are TA'd. 19 is in DocuSign pending a close read. 20 is technically signed, but we made an adjustment and the new one is in
That, yeah,
DocuSign.
new one's in DocuSign,
Right,
yeah.
okay. 21 and 22 are TA'd.
Mhm.
23, you brought us today, 3/28/25.
Mhm.
24, you brought us today, 3/28/25. 25, you brought us today,
Mhm.
3/28/25. 27, you brought in, December, I think, and we verbally rejected it again.
Yeah.
28, you brought us today, and that's back on our side of the
Wait a
table.
second, that was 26, right? 26.
I had it starred, it was the housing one.
Yeah, housing, I think we had,
Okay.
10 for is 27,
Oh,
yeah,
okay.
okay, I think that's what we have in.
I think that's the one it was.
Yeah,
I'm not sure why we had it as 27, but I have it on here as 27 asterisk.
yeah,
So
'cause I
there
think
is no
28 is-
26?
I think we skipped one because we both had some early ones, because I think we had initially brought 26 as the professional development proposal that you all rejected.
Right.
And then you all had brought housing as 27 in quotes, and then 28, I think you all brought in quotes, because
Yeah.
they're all new.
that's what
Like,
I
they're
have,
not currently in here.
yeah, that's what I have noticed, so we have to
Okay.
change 28 to match whatever.
Whatever
it
the
ends up
next
being,
one
but
would
yeah.
be. The only other one that I have that we haven't really talked about is the current 26, which is definitions.
Definitely.
So neither of us have exchanged proposals on that one.
Wait, sorry, what was that?
20, the current 26 is definitions. Um. I don't think there's anything, and just as kind of
Yeah.
for purposes of discussion, I don't think we have a whole bunch of stuff in there. The only thing I wanted to say. In a general sense, and I don't know if you think it would be worth doing it, is we have kind of both taken turns trying to make the language consistent with a couple components of it. One being, do we use employee? Do we use bargaining unit member? Do we use GA? Do we use graduate assistant? Like, we've kind of gone kind of all over the place with that. So I don't know if it's worth giving it a review, at least on the ones that we still have open, to try to, do you guys have a preference, I guess? Before we go back and wordsmith some of these, do we want to talk about what the convention should be to try to limit how much of that cleanup we have to do in the future?
Yeah, I mean, I don't specifically have a preference, I think we've been using GA as our default for
For
most
that,
of these,
Okay,
yeah.
so like the first time it appears in an article, graduate assistant, and then thereafter in the article, say GA.
Yeah,
Okay.
It's more of a convention thing. So we don't have to keep trying to talk about it and fix it.
That's what I did today for 4.8, is I
Okay.
wrote out graduate assistant the first time and then I shortened it.
Okay,
Yeah.
And they're both in there for definitions. So I think we're-
that's what I'm trying to just make it consistent. I think
Yeah.
we're
and
getting
that's why there was,
close.
especially in, I think it's Article 13, when we talk about relationships with other employees.
Yeah.
We had to redefine employee to
Right.
match like
Yep, yep, yep.
non-GAs in that case, but
Okay. Great.
yeah, so I think
Uh,
there's nothing on our side of the table by that math.
Yeah,
We
I think-
cleared out everything we had,
Yep,
so.
and, I'm gonna endeavor to bring as much as I possibly can back next week. So,
Okay,
Yeah.
all right,
Oh, it does say employee member of the bargaining unit, in this definition.
for employee.
Yeah.
Yeah,
That's why we
that's why
redefined
you-
it.
That's where we
Okay,
redefined to say for
Redefined
purposes of
Under-
this specific subarticle, employee is.
Oh,
perfect,
perfect.
Yeah,
Okay.
yeah,
yeah, because it talked about relationships with other
Right.
university employees,
Right.
not
Not
members,
employees
which
that's
could
defined
be
there.
a member of the bargaining unit, but it could also be any other
Right.
employee of the university who's
Good.
not covered by the contract.
Yep.
Mhm.
Great, all right, thank you all.
thank
We
you.
will see you next week.
Yep.
Thank you.